Good morning and welcome to our webinar. So my name is Rachael Hawkin and I'm an associate in the Health and Social Care Advisory team, and I'm joined today by Rosie Harding, solicitor in our team as well. So here in Hempsons we do a broad range of work. Rosie and I have got key practice areas which are on the screen. So court of protection being the main one, and that will be the focus for today's webinar. We also look at primary care, community care, social care and CQC challenges. So today, as we've set on the next slide, our focus for this webinar this morning is going to be very much court of protection focus. We've split it into two parts to focus on Section 21A challenges in the first part. So we'll look at what they are, the deprivation of liberty safeguard, who brings them, parties, and predominantly, because this is aimed at social care providers, how might your business be affected? Where are your resources going to go? How much time might be allocated and so forth? And then we'll go into the second half of the webinar, which will be looking at practical hints and tips. So information provision, both formal and informal, disclosure, GDPR considerations and visits, those types of things. So let's begin. So part one, Section 21A challenges. Everybody, I am sure, on the screen is familiar with a Section 21A and a DOL. So what I wanted to do is, given it's 10:30 in the morning, is to make sure that we recap on the basics. So you'll hear in this webinar a lot of reference to P. That's a reference to the Mental Capacity Act, which defines P as the person, so the person who is central to the proceedings. So that is likely to be your service user. Deprivation of liberty, we will not be here if the person that we are considering is not subject to deprivation of liberty. So what is that? Again, it's the acid test in Cheshire West, where we have got an individual who must lack capacity. And it's worth saying here that we need to have somebody that lacks capacity. We're not talking about vulnerability. For court of protection, you need to lack capacity for that jurisdiction to be engaged. We're then looking at whether or not P is under continuous supervision and control, and whether or not P is free to leave. And remember here that that's hypothetical. They don't have to have tried to leave. They don't need to keep making attempts to leave. But if they did, would you want to bring them back? If so, that is court. And then finally, you have a deprivation that's imputable to the state. And I put here funding contribution awareness because whilst predominantly imputability means funding, in practice, we're seeing a number of cases where this definition, if you like, is being expanded to those that have a contribution. So by way of third-party contribution or even an awareness can trigger the imputability section. So if we've established that an individual is subject to deprivation of liberty, there needs to be a safeguard. And so that's when we move on to the next slide, where we look to see what the mechanism is by way of a safeguard for the standard authorisation that has been put in place for this individual. And that is where we come to the nitty-gritty of Section 21A of the Mental Capacity Act 2005. So we're in circumstances here where P is deprived of their liberty and they are subject to standard authorisation, and these only apply to those in a care home or a hospital. The deprivation of liberty safeguards via Section 21A don't apply to other settings, so we're not going to be looking at them today. They're covered by other settings in the court protection, such as streamlined procedures, and otherwise a bit of a cloudy area for those under the age of 18. And again, Section 21As only apply to those who are 18 and over. So that's the bracket of service users that we're looking at: care homes, hospitals, deprivation of liberty, and 18 and above. The main element that we need to see for a Section 21A challenge to be triggered is P giving an objection. The objection threshold isn't defined, but it's very low. All we need to see is a clear and consistent objection. That objection doesn't need to be raised repeatedly. It can have different formulations depending on who they're speaking to, but there needs to be a satisfaction that an objection is being raised by P. If that happens, then we need to trigger this safeguard to ensure that their human rights are being protected. This is where Section 21A requires an application to be brought to the Court of Protection. And the benefit of having a Section 21A to bring this before a judge for consideration is that P is automatically granted access to legal aid. So it's not means tested, which means that the representation point for P is quite easily overcome, which is different for welfare applications, for example, which sit within the Court of Protection and are beyond the remit of this webinar. So we're now looking at Section 21A, which is a distinct set of proceedings in court of protection. And on the next slide, I wanted to look at the different types of scenarios where you might have a requirement for a Section 21A challenge to be brought, because depending on the circumstance of the case, that then impacts the way in which and the extent to which a social care provider might be involved and what information needs to be provided and so forth. So the three most common scenarios are on the screen. A and B, Rosie and I will see in practice a lot. So scenario A is where you have P who's in the correct placement, the service is meeting their needs, and there's no alternative available options, but P continues to object. So an example of that scenario might be that you have an individual who needs are all being met, everybody with an interest in their welfare is content that they are in the right placement, but P themselves is objecting because they perhaps want to go to an alternative placement that's not available. So for example, a family home which no longer exists. That scenario will be captured. Whilst everybody is satisfied, as far as we can see, that they are in the right place, we still need to engage the safeguard procedure and explore the objection. That will then involve information provision from the Commissioner predominantly, which will need to set out in witness evidence to the court why we think that they are in the right placement, meeting needs, and the search that's been taken to satisfy that what P is asking for either doesn't exist or it's not appropriate, and therefore it doesn't sit in their best interests. On the converse to that, we have scenario B, where actually P might not be in the best placement. So it might not be meeting the qualifier requirements to being least restrictive, or it might not be the appropriate environment because of the demographic of other service users, for example. This is where you'll find that the Section 21A information gathering process is a lot more intense. You'll be getting questions from the Commissioner as to what their needs are, how that can be met, and they'll culminate in a balance sheet analysis of options. That will then be brought before the court for a best interest decision to be made and any review of the standard authorisation with conditions, which might be needed to ensure that they stay in the current placement, but it's monitored. So there are different circumstances that come up in each scenario. The third one, scenario C, is where P themselves are disputing that they lack capacity. That we don't necessarily come across that much as in terms of a strict scenario on its own. But in that scenario, you'll be looking at capacity in the first instance, because again, we're looking at court of protection. And if capacity is not engaged, then there is no jurisdiction. If an individual has capacity, court of protection plays no role. Looking at the different types of objections, as I've said, we need an objection and to ensure that we can then trigger the Section 21A safeguard. Clear and consistent objection is what we're looking at, but the content of the objection doesn't really matter that much. So it could be the level of restriction that they're at. They could be objecting to the care provision. They could be objecting to the environment that they're in. And it's all about ascertaining what that objection is and getting representatives on board at an early stage. So via an IMCA or an RPR. And ideally, with communication with the current placement, you might be able to come to a bit of common ground and it satisfies the objection. If that can't be satisfied, then we need to make sure that those who are in the right position to do so promptly make an application to the Court of Protection under Section 21A. Which then brings me on to the next slide, which looks very briefly at the lifespan, if you like, of Section 21A. Section 21A once started and we're in Court of Protection proceedings, and we'll go into the details of how we do that in part 2 of this webinar. But once we're in Court of Protection, then we are very much so dictated to by the court timetable. The practice directions say that we should move through Section 21A applications very swiftly. We have an individual who is objecting to their placement, and we need to make sure that their human rights are being reviewed appropriately and promptly. The first pillar in proceedings from the Court of Protection, as I said, and it comes up a lot, is that we need to establish capacity. So we need to make sure that the proper assessments have been undertaken. If it's disputed, you might need to bring in a Section 49 report from a trust, for example, to ascertain that we have clarity on the capacity position. Once we've established and the court is satisfied that there's reason to believe that this individual lacks capacity, the court then moves on to look at establishing wishes and feelings. And this is an element where service providers in particular are probably going to be involved quite a lot, because we'll be looking here to establish the wishes and feelings of P and also those with an interest. So that's where we look at those delivering the day-to-day care for the individual on the ground, their relatives, their families, visitors, an example. The commissioner is normally the person to do this, or the supervisory body that's put the standard authorisation in place by way of information sharing. It's those representing P who will then bring it all together and provide statements setting out wishes and feelings. Once we have that and we have funding information from the commissioner about available options, this is where we bring in the balance sheet analysis of options, which will look at, for example, retaining the current placement, moving to their own home, an ISL, moving to the family home, a residential placement, an alternative placement type. And then everyone is brought together who's in proceedings to an RTM, roundtable meeting, and then we will have a best interest meeting, and then that is all brought to the court to seek a final order as to what we consider to be in the individual's best interests. Section 21A and Court of Protection generally is not meant to be adversarial. It's very much so for social care providers at this point an information gathering exercise, and it's all about making sure that we get enough information to be able to make a proper analysis of the options available to P, and to make sure that the issues that are being dealt with are doing so exponentially, and we can establish best interests. So on the next slide, I'm looking at what the Court of Protection can do within a Section 21A. And within the proceedings and what culminates in a final order is the court determining any question relating to whether or not P meets one or more of the qualifying requirements. So the qualifying requirements in the Act are age, mental health, capacity, best interests. The court can also determine any question in relation to the duration of a standard authorisation. So it might be that you have proceedings where the standard authorisation is authorised for a shorter period than normal, or you have cases where a best interest assessor has only put a standard authorisation in for a short period of time because it's then going to be brought to the court for consideration. And the court at that point, after the process has been considered to explore the options, is happy for the standard authorisation to be extended. The court can also determine any question relating to the purpose of a standard authorisation and also conditions attached. So that could be, and we see it commonly in cases, having records of objections being kept by the supervisory body in conjunction with the manager of the placement. And the conditions should be tailored to P and what is suitable for P, with a basis of trying to avoid a situation where we're having to come to court again. And the Court of Protection finally can make an order varying or ending a standard authorisation and directing, or rather directing a supervisory body, the local authority, to do so. So this is very much a whistle-stop tour of what Section 21A is. I'm now going to hand over to Rosie, who's going to look at who brings the challenge now that we've ascertained the criteria that means one should be brought. So I'll hand over to Rosie.
Thanks, Rachel. Good morning, everyone. So as Rachel said, I'm going to take a brief look first at who brings a Section 21A challenge. And we're looking here at who makes the application to court to start the process. So it's possible for P themselves to issue Section 21A proceedings if they have capacity to do so. That's much less common in practice, and most commonly a Section 21A application will be issued on behalf of P. So as you'll all be aware, residents who have DOLS authorisations in place will have a relevant persons representative as part of that, otherwise known as an RPR. Where that RPR is unpaid, so it could be a family member or a friend, they will also have an appointed IMCA. So case law is very clear that the RPR is the person with the duty to apply to court for review of the qualifying requirements where P wants them to, or where they believe that P would want them to if P could communicate, or where the RPR themselves considers that one of the qualifying requirements are not met. Where P has an IMCA as well, the IMCA will take practicable steps to help the RPR to apply to court where it's necessary. So in terms of the practical process, to apply to court, the RPR will usually approach solicitors who will represent P throughout the case, and I'll go into a bit more detail on that in the next section. If the body commissioning the care package or the supervisory body becomes aware that P or someone else, a family member for example, is objecting to the placement, or they don't consider that one of the qualifying requirements is met, or the RPR or IMCA has failed to take sufficient steps to challenge the authorisation in the way that they're supposed to, then the commissioning body or the supervisory body would have the role of doing so, that they would be the body to make the application. The point to take from this is that P's objections must be listened to, and as Rachel pointed out earlier, there should be a low threshold for taking this to the court if attempts to resolve the situation on the ground have failed. So if you have a resident in your service who you feel may be objecting to their placement, raise this with the RPR, the advocate, or the commissioners, and ultimately someone must take action to ensure that it's reviewed. If you move on to the next slide, Heather. Thank you. So we'll have a brief look at who the parties to a Section 21A challenge will be. As part of making the application, those issuing proceedings have to think about who should be involved on a formal basis and joined to the proceedings as a party. So P themselves will be represented. I'll go through briefly the different types of representation that P might have, because you might hear the use of different acronyms, and ultimately these are the people that you'll probably be interacting with as a social care provider. So most often P will have a litigation friend in the proceedings. Sometimes the RPR could take on this role themselves, and they'll be the person instructing solicitors to act on P's behalf. Where the RPR can't take on the role, for example, if they feel it might affect their own relationship with P, if there's a conflict between P's wishes, for example, and what the RPR thinks is actually in their best interests, or sometimes because they just don't have time to do it, the official solicitor can, in those circumstances, be appointed as the litigation friend of last resort. So the official solicitor is a single person, her name's Sarah Castle, but her role may be discharged by her internal team of lawyers, or it can be delegated to an appointed external firm of solicitors. So where you're liaising with an official solicitor, it could be a different person every time. Sometimes instead of the official solicitor, P can be represented by an accredited legal representative or an ALR. Now, an ALR is a solicitor who's authorised to act on behalf of P directly, even where P lacks capacity to instruct them without need for a litigation friend. I think Rachel might have mentioned earlier that P will receive non-means tested legal aid funding for their legal representation throughout the proceedings, so there won't be a cost to P for challenging the authorisation. Whoever represents P, broadly, the role of their representative is to find out what P's wishes and feelings are and to communicate them to the court and other parties. So this is usually done through attendance notes from visits to the service. We'll speak about that more later in terms of information gathering. The second part of their role is to keep P informed as to progress within the proceedings to ensure P is aware of their rights. This might include, for example, letting them know that they can speak to a judge directly. Ultimately, their role is to make decisions in P's best interests. So this could include agreeing to take the position that a new placement is in P's best interests and that P should move on from there, or taking the position that the current placement is in P's best interests and they should remain there, even if that goes against P's wishes and feelings. On the next slide, we'll have a look at the other parties that might be joined to proceedings. They're known as the respondents. Who becomes a respondent will depend upon the circumstances of the individual case. The court will always seek to be proportionate to ensure proceedings don't become unmanageable, so we won't get reams of different bodies and people being joined, but there are some usual suspects. So those are commissioners. Whoever commissions the care package will be joined, and they'll have a central role in, for example, establishing what the available options for residents are. This will usually be the local authority if someone's 100% social care funded, the ICB if someone's NHS continuing healthcare funded, or sometimes both if they're funded jointly. The supervisory body, so the local authority, who's the supervisory body for the purpose of the DOLS authorisation, will also be joined. This is on the basis that it's their authorisation being challenged in circumstances where they've deemed the requirements for the authorisation are met. A less common type of respondent is NHS trusts. That may occur in circumstances where P's objecting to a long-term hospital stay, or where they're objecting to discharge from hospital to a specific care home. And finally, we do often see family members join to proceedings. They can contribute informally, but they're able to join as parties if they wish to, if they want to take a more formal role, if they want to speak to the judge directly, for example. And they'll usually be joined if they have particularly strong views on whether it's in P's best interest to remain in the current placement or not, or on whether P has capacity or not. Now, you'll see from the last point, despite your pivotal role in all of this, it is, as you're likely aware, very rare for social care providers themselves to be joined as parties to proceedings, but it's not impossible. We most commonly see it occur in cases where, for example, there's been issues with the provision of information into the proceedings, and we'll go on to cover that in quite a bit more detail later on. And with that, I'll hand you back over to Rachel to begin part 2.
Thank you, Rosie. So we're now in the second half of our webinar, where we'll be looking at practical hints and tips. So a bit of a recap here about how your service may be involved. And as Rosie rightly pointed out, you're unlikely as a service provider to be joined as a party to proceedings. That's not to say that you can't be, and that there aren't certain circumstances where it's appropriate for you to be so. But in the majority of our experience, it's very much an informal role that you're playing, but nonetheless a very important role. I often find it quite curious that as a social care provider, you know P the best. For those who you're providing care to in a current service, for example, you're with them on a day-to-day basis. The care team, the support team know P very well. So your information on them and your input is very valuable. So whilst you might be playing a peripheral role in proceedings, one takeaway from today, if nothing else, is that communication is key. It's really vital that you ask those who are giving you information, for example, or asking you to input into proceedings, what's going on, the background, where they are within proceedings, because whilst we appreciate you're very stretched and you've got so many services to look after if you're a provider and different things in your day-to-day activities, these proceedings are very important for P and for that service user. So you'll be very much likely on a peripheral role, but an important role nonetheless. You'll be there to assist the court and the parties in information provision. And we'll be looking at information provision shortly, which will split into formal and informal. But again, it's about, as well as communication, it's really important to set out your views to the RPR, care coordinator who is involved in P's care as it might be. What are your views? How do you think that things may improve for P? You've heard the objections that are being raised, potentially you've been documenting them in your daily notes. Is it an issue that's such as common as, for example, needing more access to the community? If so, how can you provide that? Do you need more funding? Does P, in your view, warrant one-to-one funding for an activities coordinator, for example? We have seen previously that actually when you get down to the nitty-gritty of the objection being raised, it is really common for something quite simple on a day-to-day basis to change. You need to do that in collaboration with the commissioners, but often when that happens and you have a bit of a trial period, then P actually settles back down and then the objection can sometimes fall away, or parties in the court find it a much more straightforward process to conclude proceedings. You're also going to be there to help facilitate P in their participation in proceedings. Rosie's set out who formally represents P in proceedings, but this will involve them having visits from their litigation friend or their RPR. How does that take place? Where does that take place? And often it's the social care sector that sees that on the day-to-day basis. So it could be in the case of getting formal private rooms for those conversations to be held, making sure that those visiting are aware of P's daily routine. And when is the best time to visit P? Those providing care on the ground are the best to know that. So again, it's interactions with P to assist in determining wishes and feelings. Again, I keep saying communication is key. Let your views be known. If you don't think it's been properly documented in the daily notes or whatever, or actually there's an update, then you should feel very confident in communicating that to those who are contacting you about these proceedings. The other way that you'll be involved as a service provider is receipt of final orders, which might stipulate conditions, as we looked at before, to be attached to the standard authorisation that's been reviewed as part of this Section 21A challenge. You may also be in receipt of various orders as the proceedings progress. So, for example, not overly commonly, but perhaps directions orders setting requirements for RTMs to be set, in which you'll be invited to, and also things known as third-party orders, disclosure orders, which I'll come on to in the next slide. So the reason that I wanted to talk to you about third-party disclosure orders is that as a social care provider, you will no doubt have received them. And we do see quite often that they are sometimes put into a too difficult pile because they can be very onerous, particularly when, as we've said, you're on the periphery of proceedings, you're not expecting it, you might not know what the current status of proceedings are, and then you get a formal order of the court demanding that you do something by a certain date. Compliance is key. Again, it's an order of the court and you must comply. If you think that there is any issue in your ability to comply with the order, then again, communication is really important. You need to be very clear about that and transparent and say to those who provided you with the order, more likely than not, the official solicitor, who would be applicant for P, for example, in proceedings or their RPR, and say to them, I'm not going to be able to comply with this. And that could be because the request for third-party disclosure is too onerous, or it covers quite a large period of time. So you need to review it very carefully when it comes in, check it, read it, look at it and think, what is this asking me to do? Can we in any way narrow the request for disclosure? Rosie and I in particular in proceedings will try and make sure that third-party disclosure orders are very specific and that they're not drafted in a general and broad term. Often you see them identifying a third-party body being required to provide disclosure, and the same one is copied to numerous. So that could be an NHS trust, a mental health trust, the social care provider, or otherwise. And you might have had the service user for years. They may be a long-standing resident with you. It's not always necessary for every single documentation that you've gathered on the service user to be provided. So what you need to do is try and narrow it if it hasn't been already. If it's a generic order, you need to be asking questions about what class of documentations they're after. Is it daily notes? Is it records of objections? Is it activity charts? Is it things like Mars charts, for example? Do they need to be looking to try and get a time frame for when that disclosure applies? Often you find in quite complex cases that you'll have rolling requests for disclosure and they'll become inbuilt into proceedings. So they're all very important. And because it's an order of the court, if you've got any questions, then you should seek legal advice. Do that as soon as possible, because then we can at least communicate with the court as to the difficulties that you'll have with compliance. It's also worthwhile when you know that you've got numerous service users subject to court of protection proceedings, thinking about how you keep your medical records. Are they electronically stored? Are they paper copies? If so, that's going to be quite onerous to scan months worth of paper records. If you're working with a digital information provider, for example, in your dashboards, how does that work? How can you utilize your dashboards to make it easily accessible with records for certain users who you know might be subject to proceedings? The other way of looking at formal information provision, which you might be required to do as a social care provider, is not through necessarily just providing copies of information, but it could be in being asked to provide a witness statement. Similar to not often being joined as a parties, it's not always very common for a social care provider to provide a witness statement, but I have seen it. And whilst it is a scary thing to see, an order, this is again your opportunity to be very honest about what is happening with the service user. If you receive an order requiring a witness statement to be provided, again, you need to really clearly read this order and consider, what are you being asked to provide? Who is best placed to provide that information? Quite often it's the manager of a team who works in conjunction with care coordinators, for example, and the care providers. So it's very much a conjoined approach, but there needs to be an individual assigned to this witness statement who at the end will be asked to sign a statement of truth. And this is why it's very important when providing formal information to the court, because this witness statement will sit on the court file. It will form part of the bundle that's going within proceedings. And as part of the statement of truth, it's essentially akin to making an oath in court. So you need to be absolutely satisfied that you believe the contents to be true. You'll sign your name and your date that you've signed it. And when you've provided written witness statements in proceedings, that does then mean that actually you could be asked to be a witness to give oral evidence at any final hearing required to determine the application. So don't treat them lightly. Get support where needed, seek legal advice in the same way that you would for a third-party disclosure order if you're not very sure, or if those who provided you with the order don't seem to be able to articulate what it is that's needed. And again, you will have a certain time frame within which to provide the witness evidence. If you think that there's going to be any issue with compliance, then that needs to be raised at the earliest opportunity. Courts are very flexible in the way that they look at the court timetable, and parties do have an ability to make amendments to the court timetable by agreement, as long as a hearing date is not prejudiced. So there's always room for moving if you need it. But what I would definitely advise against doing is getting worried about something, putting it on the too difficult pile, because you will then receive lots of requests, and the longer it goes on, the more impact they will have within proceedings, and the urgency very quickly ramps up. Section 21A proceedings, the lifespan of them are tended to be very short and very swiftly dealt with. So where possible, if you're not sure, raise it, and communication again is key. So we're staying here on the formal information provision before Rosie picks up on informal information. So continued considerations as how we give information formally within proceedings. We've looked at third-party disclosure orders, witness statements, which you'll be ordered to provide. There are other ways in which you might be involved, and predominantly that will be through assessments, judicial visits and peace participation. We've covered this slightly before, but in the context of assessments, you might be asked to provide, or at least input into, or provide copies of assessments that have previously been undertaken in relation to capacity. You might not be assigned to a social care provider as such, but you might be asked to go out and see P to provide your views on capacity in whatever domain is relevant to the proceedings. You might be asked to provide information to the Commissioner by way of an assessment of a desktop review, because you are not currently providing care to a service user, but you might be a prospective service provider when the Commissioner is looking at alternative options. They often form desktop reviews, which are based on your service specification or your quick, brief assessment of need, and then you go back to them saying whether you can or you cannot meet their need. That all forms part of a balance sheet analysis as to what options are available for parties in the court to consider. Judicial visits is something which looks different post-COVID, in my view, to what they did pre-COVID. And that's often where P, who is the subject of its proceedings, might express a wish to speak to the judge. Judges sitting in the court protection are very well versed at speaking to individuals, and often you have so much information flying around and hearings and other things going on that it's often common to forget that actually P is not being kept up to speed in the same way. And we need to make sure that P can set out their views to the judge in the best way possible. Often now post-COVID, you see that with remote meetings. So that's where they will be held in private. Judges often sit in their chambers in court and their video link out to P. What does that look like for P? They'll need a room where they have support from those who are comfortable with them. So, for example, care support sitting in with them, that's absolutely fine. They'll also probably need somebody there by way of their representative, and also practical hints and tips on how they access court links and doing that for them. Often, pre-COVID, you'd find judges coming to care homes or where P resides in their own home. That you're increasingly seeing less of, really. It's very much a case of remote. And we're all very well versed in setting up those links, but P may well not be. But that's another way that you'll formally be involved. It's worth saying that proceedings in the court protection are subject to transparency orders. So anything that you hear or come across should be kept confidential. You're there purely to facilitate P joining in that conversation. Whatever is discussed should still remain private. As well as helping P to join in with judicial visits, you'll also find yourself quite commonly coming across issues about how does P access the hearing. So again, that's very much part of practical support and participation for P. You getting space in a private room, so they're not in a communal lounge area, for example, and making sure that they are comfortable in what's about to happen. This isn't to say that you have to advise P. That's a role for P's legal representative, but it's about being there as a bit of a support network. And so moving on to the next slide. Thank you. This is where I will now hand over to Rosie to look at the informal information provisions.
Thanks, Rachel. So yes, in addition to formal information provision, the provision of information on a more informal basis is really important in proceedings. As the care provider, you and your staff are the ones that see P every day. You're the ones that understand the nuances in their presentation, the ones who notice change, and who can ensure that all of that is properly communicated to the parties to proceedings and ultimately to the judge as the decision maker. So we're going to have a look at a few of the common ways in which you might be expected to informally provide information into proceedings. The first of those is providing information to commissioners. So I pointed out earlier that the commissioner will usually have a pivotal role in 21A proceedings, and they'll be the one setting out in evidence updates as to P's presentation, new issues or changes, details of available placements, and giving their view on P's best interests. And the commissioner is highly likely through that process to be required to provide information. It doesn't hold itself, so it'll be reliant on the care provider to a certain extent to share that information with it. It's the role of P's representatives to obtain P's wishes and feelings for the purpose of proceedings, but the commissioner will, as Rachel pointed out, have a role in this too, and they'll look to you, for an example, for an understanding of how often P raises objections or wishes to leave. They might ask you at the outset of proceedings to keep a log of objections or any expression of a wish to leave. Even if the commissioner doesn't, I'd suggest it's good practice anyway, so that you've got that information on hand and ready to share. We've discussed already that another point that comes up regularly in this type of application is activities offered and access to the community for P. Commissioners will often be asked to provide very detailed updates on those points, and keeping really detailed records on them is important so that you've got that information ready to share. Commissioners will also often be asked to provide updates on any health referrals or input from other therapies, and they'll need that information to come from you. So having that detail ready to hand and ready to share is really important. Key point to remember, as we've already discussed, is the fact that commissioners and all parties to proceedings will be working to a court-directed timetable, and the requests for information will often tie in with that. So if a commissioner has a witness statement coming up, it's very important that you're able to provide them with the information requested by the date that you're asked to do so, because if you don't, it may have a knock-on impact on their ability to meet court timetable. And of course, if you're unable to provide the information, then as Rachel set out numerous times, communication is key. Let them know by when you'll be able to get the information to them, and then they can liaise with the parties to the proceedings. If you don't do that, they will have to communicate to the court and parties as to why they can't provide the information. And if care providers repeatedly fail to provide information, that is one of the points where the court might consider it necessary to join them as a party to proceedings. So the second way in which you might be asked to provide information into the proceedings is through visits from P's representatives. This primarily will be through the visits primarily are for the purpose of speaking to P and getting their wishes and feelings, but they're often much wider in scope than that, and you'll usually find that P's representatives want to ask the management or some staff who care for P on a day-to-day basis questions too, and that can sometimes, where P is unable to properly communicate, form a large part of the visit. Often a member of staff will be asked to sit in with P during the visit, as Rachel's been through, and they might be asked as someone who knows P well to assist with asking P questions, or to help the representative who knows them less well to interpret the answers that P gives. In addition, as I said, representatives will often speak with management to ask questions about P, their presentation, and topical issues which have been raised within the proceedings. When this happens, it's nothing to worry about. It's all very standard. You just need to answer the questions openly and honestly. Having said that, it's very important to remember that these visits are usually closely minuted, and the minutes are shared with the court and the parties through an attendance note. The attendance notes are often intended to be verbatim, almost word for word documentation of the discussion. So I'd suggest wherever you have had a discussion with representatives, if it's not offered to you, you ask to see that note before it's shared with the court and parties, so that you can ensure that you're happy it accurately represents what you said, or you can ask for any changes to be made before it is shared. Of course, having said something, you can't ask for that to be removed or changed, but you could ask the representative to add a note for clarification if it's something you feel you could have worded better, or something that perhaps could be misinterpreted. that can be done after the event. If we move on to the next slide, the final point that I want to discuss with you in terms of informal information provision is attending RTMs. So they're roundtable meetings, often abbreviated. An RTM is a meeting between parties without the involvement of the court, which is intended to allow for discussion between the parties to determine the level of agreement between them, to define the issues that do and don't require the input of the court at that time. So in line with judicial visits as well, lots of these used to take place in person, but it's now almost unheard of. The large majority take place by Microsoft Teams, which helps to facilitate people's attendance and has the benefit of it being easier to organise, but does lose the human aspect in some ways, shall we say. So in some cases, it might be appropriate for P to attend, and you'll be asked to facilitate P's attendance in the same way as Rachel discussed in respect of hearings and judicial visits. Usually, if it's not P, it would be the care provider that's asked to attend to provide an update on P's presentation. So for that purpose, it's really helpful to go with a sort of pre-prepared summary of P's recent presentation to share key points that relate to their changes in need, behaviour, any key events, highlights, incidents, and if you know that a specific issue has been raised within the proceedings, like community access, to make sure that you're able to give a good summary of how that's looked for P lately when you attend the meeting. Again, RTMs are minuted and those minutes may well be shared with the judge, so just be mindful when you're sharing updates or when you're asked to give views of that. And if you're a care provider that's asked to attend, but you're not a party to the proceedings, then your attendance, just to be mindful of it, your attendance may well be limited to providing that update and then responding to specific queries. And you might be asked to leave the meeting so that parties can then discuss matters which are specific to the proceedings, which it's either not appropriate to share or which we just don't need to take your time up with. So I suppose a final point to note on RTMs is that they're intended to be a forum for information sharing and for parties to discuss next steps. They're certainly not intended to be a cross-examination or an interrogation, and they are nothing to be feared. So if you're asked questions, answer them openly and honestly. And if you are concerned by anything that happens at an RTM or any questions that you ask, then seek legal advice at an early stage. We'd be more than happy to help with that. I'm just going to go on the next slide, a few hints and tips in terms of record keeping. So it brings us back to a reminder that your records might be scrutinised by commissioners, family members and legal professionals and the court as part of these proceedings. So I just wanted to give a bit of a reminder really to ensure that your records are consistently in good shape. So similar issues crop up time and time again in this type of case, and it's important that the parties to proceedings are able to easily find the information that they require within your records. So I've popped on the screen some particular areas of focus, being P's current presentation, daily notes and communication logs, evidence of escalation, deterioration in needs or behaviours, evidence of patterns, and being able to identify those is really important, particularly in the case of incidents. Often there's great interest in activity planners, records of community access, what went well, what didn't, use of PRN or covert medication, use of PMVA and physical restraint are often really closely looked into. Of course, capacity assessments and best interest decisions, and again, logs of objections and wishes and feelings. So being able to provide that, having it ready at your fingertips in an easily accessible way can really assist with progressing proceedings. In a recent case I've worked on, the provider started to prepare a weekly summary which set out a snapshot of the above issues essentially over the course of just a couple of pages, which they circulated to the commissioner each week, and the commissioner was then able to exhibit their witness statement. It ensured that the commissioner had much of the information that they needed when it came to drafting their statement already, and it meant that the commissioner could week by week keep a very close eye on the position to raise any queries at an early stage, so the provider wasn't being bombarded with queries with short timeframes for response when it was coming up to a witness statement being required. So if we move on to the next slide, please. we all know that ensuring your records are accurate and up to date is necessary for regulatory compliance and to ensure that your service runs properly. But in the context of court of protection proceedings, providing full, complete and accurate records can both reduce the number of additional questions that you're asked to answer throughout the proceedings, and ultimately it can reduce the risk of you being joined as a party to proceedings and the sort of cost and time implications that has. And I think that is the end of my slides. So I think we're moving on to questions and discussion now.
One that just came in at the beginning, which I'll answer, and then I think we've got a hand up from Emmy, is whether or not hospices are included in that list. And yeah, so it's registered places. So care homes, hospitals, including hospices, very much depends on whether they're registered. But generally, yes, you see less of them for hospices, predominantly due to the nature of circumstances being considered. So yes, Emmy.
Hi, good morning, everyone. Thank you for that. Super interesting as always. Really great takeaway messages. Super helpful again as a provider. I'm just curious, I suppose, on the stats. I may have missed it as I sort of missed the very beginning. Apologies for that. But what's the success rate for P challenging, and how often they may get their wishes heard to actually move on to another placement or home or, elsewhere? I'm just curious about, the true voice of P.
It's difficult to put it into a statistic, but I think in terms of having the true voice of P being put forward, I would say in all cases that we're involved in, there is definitely a high level of that. P is very much seen at the centre of proceedings. COP, as I said, is not adversarial. So whilst we wouldn't be able to give a statistic or a number as to how often P is successful, if you like, because it's not seen as in a claims and adversarial manner, you'll find that proceedings will not conclude until everybody is satisfied, including P, that the correct outcome has been reached. You might find that is reflected in the duration of a lot of proceedings. Some are very quick to conclude. Others, we've had cases that go on for several years because either the correct placement isn't there or it doesn't exist, or we end up supporting parties to create bespoke placements. So in answer, there isn't really a straightforward answer, but I think in terms of trying to quantify how P is included in them and their voice, it's quite high. The court is really eager to make sure that that's put forward. If we get stuck on wishes and feelings, for example, of P, the proceedings simply stall until we get that. The commissioners can do all the work that they like, but until we know what the views are, the court won't make any decision. So I hope that answers it in a roundabout way. I mean, I know that's not a direct answer.
Sorry. Yeah, no, I think it's really great to hear. I mean, human rights advocate and all of that, as I'd hope we all would be in our roles and what we do and why we do them. But absolutely. Yeah, it's just that little bit of what brings a bit of sunshine to my day, hearing that positive feedback. So thank you.
Thank you, Emmy. Rosie, do you want to take the next one? So I've got Section 21A challenge and I'll read into the rest. Thank you.
Yes. So I've got a question. I'll read it out because I'm not sure that those, when this is published, will be able to see it. So can a Section 21A challenge be made if a commissioning team are trying to move a person from a residential home they are settled in if they lack capacity? I mean, a 21A challenge can be made in respect of any objections where a standard authorisation is in place, of course, anyone's objection to that not being in their best interests, or if a person feels they have capacity when the authorisation, of course, finds that they don't. In terms of a commissioning team moving a person, I think it would depend on the reason that the commissioning team is moving the person. The views of everyone with an interest in P's welfare should be taken into account before a person who lacks capacity is moved in any event, and P should have an advocate. But if, for example, there is an external reason, such as the home not meeting their needs, you would hope that that could be dealt with outside of proceedings, and really it depends on the reason for the move. But I suppose it would be helpful to understand, Aisha, who you'd anticipate would make the challenge in those circumstances, because if a family member didn't agree, for example, Section 21A might be the right vehicle to challenge that, but it really depends on where that objection is coming from.
Jump in, Aisha, if you'd like to contribute at any point. If not, that's absolutely fine. But I was going to say, it depends exactly, as Rosie said, on the circumstances. And Section 21As, it might be helpful to consider, aren't the only mechanism within which cases on behalf of P can be brought to court of protection. Section 21As are distinct in their application in that it relates to an individual lacking capacity, subject to deprivation of liberty, and raising an objection. You can also bring welfare proceedings within the court of protection, which are a different set of proceedings that we've not considered in this webinar. And that might be more suited if you think that actually P is not raising an objection, but the Commissioner perhaps has wider concerns as to P's welfare. And again, it's about why they're considering a move. So I think it sounds as if P is happy where they are and they don't have capacity but seem to not want to move for commissioning. We need to work out why that's being taken, and it's on receipt of information there that we can work out which is the correct pathway to get to court protection if needed. Another question that we've got is about costs. So what about costs to the provider, time, etc.? There are legal routes to get third-party costs. Are there legal routes to get third-party costs paid when they can be a few hundred? I don't know if this answer is going to be satisfactory, but court of protection is a non-cost jurisdiction. And essentially the answer is probably likely to be very unlikely no, you're not going to get them recovered, which is why when we're talking about third-party disclosure orders, it's really important to get on top of them as soon as they land. If you think that they're going to be so onerous, then you need to set out why. Disclosure requests should be reasonable and they should be limited to what is proportionate and necessary in proceedings. If you're in a position where you're having to spend weeks upon weeks and hundreds of pounds to provide this information, the time frame in which they're going to be available is probably going to be very unhelpful to the parties. So then they need to reconsider, actually, do we need to reframe our request in something that is more manageable? That in turn should reduce implications to you in terms of time and resources. So absolutely work out what you can and can't do. And to the individual that's provided you with an order, for example, go back to them as soon as you can on that, and they should raise it within proceedings and try and get to some kind of resolution so you're not in a position of incurring that amount of money in the first place.
I think Gurpreet expanded upon that question to say that once they've pointed out that the cost to the provider, they've had solicitors come in and take copies themselves or apply for a legal aid payment to cover the cost, which the solicitors coming in to take copies themselves where they've made a very onerous request is something, go for that if they're willing to do it. Absolutely, if it reduces the time pressures on your staff.
Yeah, absolutely. And what I would be very conscious to do in that circumstance is make sure that you're clear on who is coming into your service, what access they're going to have. Make sure that you've got your GDPR considerations there, that they're not going to inadvertently pick up papers relating to another service user, for example. So you still will need to incur some time before they come, but absolutely, if you're willing for them to come onto your premises for that purpose and they've got the requisite documentation to show who they are and the orders that are in place, then that's another way of getting around it as well. That I haven't seen that happen too many times. And often you'll find that there is a lot of conversation that goes on, or rather there should be a lot of conversation that goes on between the parties on the scope of disclosure before a request for disclosure is formally made. So that really shouldn't occur. But absolutely just communicate and see what is the best route for you in that circumstance. Next one, we've got an ongoing safeguarding where the husband is restricted from visiting the resident because the resident herself has expressed a wish not to be visited, with various reports of abuse. Now taking legal actions against the service. That sounds like a tricky set of circumstances. I'm not sure if we've got a direct question stemming from that. That to me hints more at a vulnerable individual, perhaps. I'm not sure on capacity points, but that I think would stem more into a welfare application rather than Section 21A, so that we're considering here. And that is something where I would hope that commissioners are alive to and supporting you with that as well. I think we have come then to the end. If we haven't got any more questions, I hope for those who have raised questions, that's answered them as far as we can in this context. As I say, our contact details will be on the slides, which will be available. As Heather's just put up there, we've got the Hempsons free social care advice line as well. Do see if you're eligible to join into that and raise any questions, or if not, contact myself and Rosie separately and we'll be delighted to continue the conversation further.